The Chairman of Committees.
My Lords, I beg to move the motion standing in my name on the order paper. My Lords, it might be appropriate for me to give the House a very brief outline of what the Barony of Farnham case involved. The petitioner, Lord Farnham, is the holder of a distinguished Irish peerage. His grandfather was elected to represent the peers of Ireland in your Lordship's House under the provisions of the Act of Union with Ireland 1800. Such peers were elected for life, and many of them continued to attend this House after the passing in 1922 of the legislation which set up the Irish Free State. However, there were no further elections of Irish peers after 1922, so that their number dwindled with the passing of the years. In 1966, Lord Antrim and a number of other Irish peers petitioned this House asking that elections should once again be held. That petition was referred to the Committee for Privileges, who reached the conclusion that the effect of the 1922 legislation had been to dismantle the electoral structure set up by the Act of Union, and that no further elections could be made without further legislation. There the matter rested until Lord Farnham's petition. It was his contention that the continuation of the issuing of writs of summons to attend your Lordship's House after the passing of the 1922 legislation, together with the findings of the Committee for Privileges in 1966, meant that a barony by writ had been created in the person of his grandfather, the 11th Baron, to which he, the 12th Baron, was the rightful heir. My Lords, that, very briefly, was the case which was argued before the committee. We were assisted greatly by the Attorney-General and by counsel for the petitioner, Mr. Jonathan Fisher. I should also like to record the gratitude of the committee for the written material submitted by Mr. Jonathan Loftus, junior counsel for the Crown. Mr. Loftus is, of course, an acknowledged expert in the arcane field of peerage law, and his valuable and fascinating memoranda helped the committee to understand the issues raised in this petition. As always in peerage cases, the Committee for Privileges relies heavily on the assistance of the Lords of Appeal. And on this occasion, the committee were immensely indebted to the noble and learned Lords Lord Keith of Kinkel, Lord Jauncey of Tullichettle, Lord Mustill, and Lord Lloyd of Berwick. With their assistance, we found ourselves able to reach the unanimous conclusion which is embodied in the report. We concluded that, in spite of Mr. Fisher's eloquence, the case had not been made out for the creation of a barony by writ. The noble and learned Lords Lord Keith and Lord Jauncey have provided the legal reasons for the committee's decision, and these opinions are included in the printed minutes of proceedings. Finally, my Lords, I would like to add a personal word, although I believe that what I'm about to say reflects the views of members of the committee. Although the petitioner, Lord Farnham, will no doubt have been understandably disappointed by our decision, I believe it will be of some comfort to him to know that he performed a significant service, not only on behalf of his family, but also on behalf of other members of the Irish peerage, the history of whose families are similar to that of his own. By ensuring that his petition was considered by your Lordship's House, and if your Lordships pass this motion this afternoon, Lord Farnham has enabled the matter to be settled once and for all, and the uncertainty ended. This is a valuable service, and I suspect that Lord Farnham would never have forgiven himself had he allowed the matter to go by default. My Lords, I would ask your Lordships to agree to the report of the Committee for Privileges. I beg to move.
Question is that this motion be agreed to. Lord Monkswell.
My Lords, I beg to move the amendment that this report be referred back to the Committee of Privileges for reconsideration. My Lords, I'd like to thank the noble Lord, Lord Boston of Faversham, our Chair of Committees, for moving his motion in such an able and succinct way. The House is indebted to him for that. My Lords, it is with some diffidence that I speak on the subject, considering, as we are, a report of a committee of our House of eminent and learned colleagues. My Lords, I'm sustained by the knowledge that here on the floor of this House we are all equal, with equal rights and duties to give our counsel. And it is our duty, each of us equally, to consider this matter before us and to come to a judgment. My Lords, it's been suggested that I am speaking today for the Irish peerage. Not so, my Lords. I speak today for the rights and privileges of members of your Lordship's House. By virtue of the Act of Union between Great Britain and Ireland in 1800, as the noble Lord has explained, the Irish peerage elected 28 of their number to sit here in our House of Lords. They had a seat in this House for their lifetime with the right and privileges of other members of your Lordship's House. When they died, an election was held for a replacement. In 1922, the Irish Free State was set up. In 1966, the House agreed to a Privileges Committee report, the Antrim case, which said, and I quote, my Lords, that the provisions of the said Act relating to the election of Irish representative peers ceased to be effective on the passing of the Irish Free State Agreement Act 1922, and that the right to elect Irish representative peers no longer exists. My Lords, in that case, Viscount Dilhorn said in his opinion, and I quote, my Lords, in one sense, the 28 elected peers were representative of the Irish peers who elected them, just as the 4 Lords Spiritual who sat by rotation represented the other Lords Spiritual. But it is, to my mind, clear that they were only elected to sit and vote on the part of Ireland. When the Free State and Northern Ireland were created, Ireland as an entity ceased to be part of the United Kingdom. It necessarily follows that there was no territory called Ireland to be represented in the United Kingdom Parliament, and therefore it was, in my opinion, no longer possible to elect an Irish peer to sit and vote in the House of Lords on the part of Ireland. For to do so would have meant the election of peers to represent a territory which had ceased to exist as a political entity and as part of the United Kingdom. For these reasons, in my opinion, that part of the Union with Ireland Act, which provided for the election of Irish peers to the House of Lords, must be regarded as having become spent or obsolete or impliedly repealed in 1922. My Lords, my contention is that the implications of that judgment was that there was no basis for Irish peers to sit in this House. In effect, the Act of Union of 1800 had been torn up. But, my Lords, some Irish peers continued to receive writs of summons and sat in this House after 1922. Since there was no other basis for their sitting in this House, they sat by virtue of a writ of summons and based on the precedent that they were effectively created for each of them a barony by writ of summons. My Lords, I believe that...
to interrupt, my noble lord.
My Lords...
Noble friend, will you sit down? Noble friend. They sat after 1922 because they had been elected for life, and it was agreed that they should continue to sit for their lifetimes, although the right to elect further Irish peers had ceased and had been repealed in 1971.
My Lords, I'm sorry the noble Lord did not listen very closely to my remarks. Maybe when he reads them in Hansard tomorrow, he may consider them more fully. My Lords, I believe that there are in fact less than 6 cases that meet the criteria, and the Barony of Farnham is one of them. The present Baron Farnham is the grandson of the first creation, his father having died as a result of wounds at Alamein. My Lords, I believe that he should receive his writ of summons. My Lords, I have been a little bit concerned about some of the things said in the proceedings of this committee. In particular, the reference to Irish representative peers. My Lords, I think we must make a distinction between the method of selection of peers and their situation once they have taken their seats in this House. My Lords, I would give you the example of the spiritual benches in your Lordship's House. They are effectively selected by the established church, the Church of England, to sit in this House. But when they take their seats, they speak for themselves. They do not speak for the Church of England. And my Lords, I think we must recognise that those Irish peers who sat by virtue of the Act of Union of 1800 did not sit in this House representing Ireland. They sat in this House representing themselves, as we are all summoned to do, to give our counsel and not represent any outside interests. My Lords, some of us sit in this House by virtue of ancient or less ancient titles, and some sit by virtue of statutory provision and receive writs of summons by virtue of those acts. My Lords, if those acts were repealed, the basis for the seat would be removed. But, my Lords, if they received a writ of summons and took their seat, there would be conferred on them a barony by writ of summons. My Lords, in conclusion, I would like to quote the words of a counsel for James, Duke of Atholl, in 1735. My Lords, he said, they insisted likewise that when anyone is called to the House of Peers and actually sits there, his blood is therefore ennobled, and his lineal heirs will be so for ever afterwards. My Lords, I hope the House would uphold the ancient rights, and it is on this basis that I ask that I move my amendment. I beg to move.
The original motion was that the report of the Committee for Privileges on the Barony of Farnham be agreed to, since when an amendment has been moved to leave out agreed to and insert referred back to the Committee for Privileges for reconsideration. The question I now therefore have to put is that this amendment be agreed to.
My Lords, I do apologise for having interrupted my noble and learned friend on the Woolsack. One does sometimes make mistakes, and I apologise for them. I hope, my Lords, that we shall not take a great deal of trouble to listen to the debate on this amendment, because it is basically nonsense. My Lords, there are, looking round me, particularly on the benches behind me, a few baronies by writ which now exist. I think my noble friend Lord Mowbray and Stourton may be one, and my noble friend Baroness Strange may be another. They existed prior to the 17th century, but were validated in the 17th century by the Committee of Privileges by reason of the fact that there was an anomalous practice of medieval monarchs to issue writs without letters patent. And they are the only writs which can exist, and they exist, I think, only in the peerage of England and not in the peerages of Ireland or Scotland or the United Kingdom. So there is not an ancient right except for those who already possess it and their descendants. Now, my Lords, having said that, since the 17th century, peerages of all kinds, whether in the peerage of Ireland or the peerage of Scotland or the peerage of Great Britain or the peerage of England or the peerage of the United Kingdom, all peerages have been limited by letters patent, and the descent only descends to the heirs general, to the heirs male of the body, because that is how the letters patent are framed. The Barony of Farnham, as appears from the report, was not a peerage of the United Kingdom at all. It was, in fact, a peerage of Ireland, which now effectively no longer exists. But it was established by letters patent, and the descent, therefore, such as it was, descends only to the heirs male of the body by reason of the letters patent, and not by virtue of any writ received. But the matter doesn't really stop there, because in fact the barony from which the noble Lord Monkswell's amendment descends was in fact a barony to sit in this house for life. That's all it was. And it didn't give any right of descent at all per se to its successors. In fact, it has been held for reasons which were referred to by the noble Lord Monkswell, but I mustn't be taken to accept the context in which he put it. The habit of electing representative peers to sit in this house arose solely by statute under the Act of Union with Ireland, which has since gone by the board and has disappeared into the lap of history. There never was anything else to it than that. They sat for life, and that was the only right they ever had. When they died, nobody else succeeded them. It was a barony for life created by statute, which is now obsolete and in effect repealed. That's all there was to it. And this appeal was as near unarguable as a point of law as anything I have ever seen. And I had to ask the House not to waste a great deal of time discussing it, but to reject it out of hand.
My Lords, I'm sorry to disagree with the noble Viscount. I don't think this is a waste of time. I would... no, no way. I wish I could support the noble Lord Monkswell for a number of reasons. In the first place, he stands for a tradition of independence, while preserving loyalty to the party, which is very enviable and should be preserved here. In years to come, many years from now, he may occupy the sort of position that my noble, my friend Lord Bruce occupies. That's some way on. And in the meanwhile, I hope that he will subordinate his independence to his loyalty in order to achieve, office in the next administration. But also, secondly, wearing an Irish Rugby tie given me by an Ulster Protestant, I certainly would have a kind of prejudice in favour of anything that would produce more Irish influence in this house. And of course, County Cavan is wonderfully well situated for that purpose. I mean, it is it's Ulster, and it's also in the Irish Republic. So in that sense, I would be also on his side. But further, I suppose I'm one of the few people, I'm very unwise in this house, I'm the only person who has any qualifications, but I suppose I'm one of the few people who played tennis as a partner of the former Lord Farnham. I mean, this gentleman we were discussing. And I'm greatly indebted to him because he got me into the final of the County Cavan tennis tournament. He was what we call in England the local squire. I mean, Farnham Castle dominated the county courts. And so we were given a colossal handicap, and we got into the final of the county tennis. I've lost one of the audience, but perhaps not everybody. I can't really see who it is. Is he shocked by something? At any rate, there was a fine man, but we got into the final. The local young men were terrified of this great lord, you see, presiding over the whole scene in Farnham Castle and the county Cavan courts and all the rest of it. But a couple of unimpressionable young fellows came from Dublin, Davis Cup players, and they'd never heard of Lord Farnham or me, so they swept us aside. That was how we got as far as the final. I got in for that partnership with this Lord Farnham. But he did say to me, I said at the end, I apologised. I said, I'm afraid I let you down. He said, you can't keep going all the time. Well, that was, I suppose, well meant, but it didn't console me very much. At any rate, that perhaps is what can be said about this case. I mean, he got into the final, but we can't keep going all the time, not to actually win. And one other recollection of Lord Farnham I must give, because I think this might endear him to the House, whatever the result of this division, if there is one. Every year there was a tennis dance at Farnham Castle. There was a tennis dance at Farnham Castle, overlooking the courts. And every year Lord Farnham was a loyal Britisher. Used to insist on God Save the King, as it was then, in the 30s. being played. And of course, a number of the local nationalists who walked out. So it was, therefore, it was always a question of whether the dance could be continued at all. But I would like to, when we think of that Lord Farnham in this house, this most loyal of British chambers, to think of Lord Farnham, having God Save the King, played 15 years after the treaty, the only place in Ireland where it is being played. So his memory should be happily preserved. But I'm afraid I can't vote for the motion. I'm abstaining.
My Lords, I wonder if I might say just one or two words, having delivered one of the opinions in this report. My Lords, the position is really very simple. What was referred to the committee was the determination of whether the 11th Baron Farnham was created a Baron of the United Kingdom. Now, he was, as my Lords will appreciate, the 11th Baron. He was, of course, a hereditary Irish peer. He was elected as one of the 28 representative peers of Ireland prior to the separation of Ireland and the constitution of the Irish Free State. And the only question before the committee, or rather the first question before the committee, was whether, when he continued to sit in your Lordship's house after 1922, when the Irish Free State was separated from Great Britain, whether he then sat by virtue of his election for life before 1922, or whether he sat by some other reason. Now, if he sat by virtue of his election for life, that was the end of the matter, because it was not, the petitioner never suggested that a barony by writ could have been created in him if he was there by virtue of his election. The creation of a barony by writ could only have arisen if he sat, if he ceased to have right to sit by virtue of his election, and he sat by virtue of his writ of summons. My Lords, the committee had no difficulty in concluding that he was elected for life, he sat for life by virtue of his election, and accordingly no possible question could have arisen as to the creation of a barony by writ. My Lords, I'd only just say this to Lord Monkswell, the noble lord, that if it were the case that any member of this House who sat here by virtue of a writ was automatically created a baron by writ, it would have followed that all the 16 Scottish representative peers who sat between 1707 and 1963 would, by their writ of summons for the Parliament in question, have been created barons by writ, hereditary, and with the right to sit in this House without regard to the election of the 16. My Lords, nobody ever suggested such an idea, and indeed in my submission the question is absolutely clear that no question of a barony by writ arises here, even if it was competent still in these days to create it. The committee considered fully the matters which the noble Lord Monkswell has raised and came to a unanimous conclusion on the matter. I will therefore support the motion of the chairman of the committee.
My Lords, if I may interject just as a stage, because I think it's only fair that somebody ought to say something in defence of the unfortunate Irish peers. I declare an interest to the extent that I am one by senior title, and I was at some stage the chairman of the Irish Peers Association. And I have to say it is a very Irish organisation, because I recognise at once that it is extremely difficult to justify representing something which does not exist. However, having said that, I find that members of the Irish peers are rather adopt the role of a Flying Dutchman and has little to nowhere to go. They're not dissimilar to the late Winston Churchill, who at one time during his illustrious career, I think I'm right in saying, found himself without a party, without a constituency, and without a bottom. And that is rather similar to the Irish peers. It would be somewhat brave, and indeed some may think it arrogant, but I don't intend to be, to take on the expert wisdom of the noble lords, lords in ordinary, and indeed members of the Committee of Privileges, some of whom I see sitting here today. And they have had the benefit of extensive advice and that sort of thing, which I can't put before the House today because, as my noble friend Lord Hailsham says, we don't want to waste too much time with it, but I do emphasise this is the last call for supper, as it were, for the Irish peers, and what I perceive, and the association perceives, to have had their privileges and rights somewhat undermined. Now, I know my noble friend Lord Hailsham is very clearly of a mind to reject most things that might be said to a contrary opinion reached by the Committee of Privileges. And indeed, he went so far as to say that a barony by writ, I believe I'm right in saying, but I don't mind being corrected, he said was only there for life, and therefore there was no question of, I'm wrong.
I never said anything of the kind, and I'm in the recollection of the House.
I'm grateful to the noble lord. To my noble friend, I thought that that's what he had said, and of course it is actually not correct. If it is a barony by writ created, is there to the descendants and so on. My lords, the Committee of Privileges paid a great deal of attention to the provisions of the fourth article of the Act of 1800. And the wording early on in one of the paragraphs showed that it appeared to be the intention of the Act that peers would be elected to Westminster by their number, 28 by their number, to represent a part of Ireland. Very well, my lords, that was accepted by the Committee of Privileges, and they gave due credence to that. But I have to point out, my lords, that under the same paragraph is roughly as follows, that all peerages of Ireland created, I'm quoting from the Act, all peerages of Ireland created after the Union shall have the rank and precedency with the peerages of the United Kingdom, so created according to the dates of their creations. That all peerages, both of Great Britain and Ireland, now subsisting, or hereafter to be created, shall in all other respects from the date of the Union be considered as peerages of the United Kingdom, and that the peers of Ireland shall, as peers of the United Kingdom, enjoy all privileges of peers as fully as peers of Great Britain. My lords, I do not believe that the Act of 1922 establishing the Irish Free State did repeal anything relating thereto from which I have just quoted. If that is so, then there could be an argument that the peers of Ireland have had their rights and privileges not so much removed but fallen into abeyance because nobody paid a great deal of attention to it, which is rather sad. And I think we are, as my noble friend the chairman of the committee said, extremely grateful to the noble Lord Farnham for producing or going ahead with this petition, as it does give him a chance to have the matter cleared, and at least we will go down with all flags flying, if, as I'm sure we will do. But I think the Irish peers have been unfairly treated. They will let us go back to the fourth article, where it is deemed that they represented part of Ireland. Now, my lords, it's been argued with some justification that on the the Irish Free State Act of 1922, that Ireland did not exist politically, and therefore they were unable to have any representation of Ireland, as it didn't exist as far as this country was concerned. It just did not exist. Well, my lords, then, if that is accepted, which I'm sure is accepted, and I don't deny it, if they were not representing Ireland, who were they representing? Now, if the noble Lord Monkswell is arguing that they were representing nobody, and were representing themselves, then a continued writ of summons being received every few years when there was a new parliament, as we all do, then, of itself, it would seem to me that there's a strong case for arguing that a writ of barony has been created. On the other hand, if they were representing Ireland, and Ireland is not a part of Ireland, and Northern Ireland is still a part of Ireland, and Ireland didn't exist politically, then they had to represent someone, and it could well be argued that they were representing the peerage of Ireland. After all, there were peers of Ireland well before 1800, and many families of Ireland gave great service to their country in Dublin, and were of great assistance for matters relating to Ireland and this country. And I think it would be a pity, my lords, if that relationship, for want of a better word, were to be removed under there's some doubt about the rights of this decision of the committee, because what is going to happen in the future? Is it possible? They didn't think it was possible in 1800 that the union of Ireland and Great Britain would ever come to an end. Therefore, no provision was made in the Act for a termination of that union. Well, similarly, my lords, in 1922, and the Irish Free State Act, there is no question, I'm sure my noble lords will agree with me, that there doesn't appear today to be any possibility of a union of Ireland with this country. But you don't know. One day that could happen. And if so, then the peerage of Ireland in this House, if they were permitted to sit by writ, as some would be, might be able to lend assistance and help to your lordships. My lords, I won't detain you any longer. I think my lords, that the Irish peerage have suffered rather badly. I don't think they've been treated entirely rightly. I think there are arguments on their sides. But I detect the feeling of the House, and it would be wrong for us to go back to the Committee of Privileges consisting of many learned, noble and learned lords, and on that basis I don't think I could support the motion moved with understanding by the noble Lord Monkswell.
Well, Viscount sits down. Could he read to the House the last sentence of the Article 4th, following upon the reference to peers of Ireland enjoying privileges of Great Britain, a sentence which he didn't read, which I think your lordships may find relevant.
Read it for him, yeah.
Perhaps I might read it for him. But they shall enjoy all the privilege of peers of Great Britain, the right and privilege of sitting in the House of Lords, and the privilege depending thereon, and the right of sitting on the trial of peers, only excepted.
Detain you for more than a minute. I am slightly amazed to hear some of the speeches that have been made today. I only can feel I had the privilege of sitting on the Committee of Privileges, where we were very well advised by the learned Solicitor General and the learned Counsel, Mr. Fisher, on behalf of Lord Farnham, who I must confess is a personal friend of mine. I would have loved personally to see in this House. But, my lords, you don't do these things, as Lord Longford, the noble Earl Lord Longford, seemed to imagine, on grounds of whether you sing the King after dinner, or whether you... And if that is the law of the land now, God help us. If you sing the red flag, do we go under Russia or what? But, my lords, nothing to do with that. Let's just say, I don't think some of the people who've spoken really can have read the Committee of Privileges as argued. My noble friend Lord Mountgarret talked about the unfairness done to the peerage of Ireland. I really must say, with all honesty, I am the first one to defend peers of any sort. I don't think they've been unfairly treated. They have been treated fairly. If your country is abolished as part of a kingdom, it's not my fault or your fault. It's the opinion of politics which has taken place. My lords, one small point. The noble and learned Lord Hailsham addressed Mowbray and Stourton. I have to say only Mowbray is by writ, Seagrave is by writ, my other one, but Stourton is by letters patent. But, my lords, I merely want to say that I think we owe a great debt to the learned, noble and the learned Lord Jauncey and the other learned lords on our committee. We were admirably advised, and we were all unanimously convinced by the arguments put forth. And no one goes into these things with feelings made up before. You listen to the case, and the case as put in the paper of the noble Lord Farnham, I think are admirably argued, and I'm totally amazed, like the noble Lord Strabolgi, as to why people should be trying to fight this case as though there's enemies about trying to do them down. It's a matter of simple law, which we all listen to with great interest, and I think it's been admirably explained by the noble Lord Jauncey.
My lords, I was a member of the committee. I'd like to say just one word. Because there is a small constitutional point which has not been mentioned. There is a theory which has got some validity in history that a barony, a hereditary barony, can be created if a writ of summons is issued in error. And there are one or two cases in history where this has happened. After 1922, the writs of summons continued to be issued. Maybe they ought not to have been, but whoever sends them out kept on sending them out. But they made it absolutely clear that they were for life. So that in this case, a barony, a hereditary barony, could not be created because the writ of summons made it abundantly clear that these were for life. Therefore, my lords, the petition must fail. I'm very sorry, but I've got to oppose my noble friend's amendment, and I hope your lordships will do likewise.
My lords, in view of the fact that my noble friend Lord Longford has introduced my name into this matter, may I ask the leave of the House to be exempt from these proceedings?
Lords, as a member of the Committee for Privileges, perhaps I could just say a very few words. First of all, my lords, as my noble friend Lord Glenamara has said, the Irish peers did not sit by a mistake. There was an original theory when we first began to sit that that the writs had been sent out by mistake after 1922. That was proved not to be so. They sat there because they had been elected for life. The Scottish peers before 1963 were elected for the Parliament, but the Irish peers, the 28 of them, were elected for life, and that was the reason why they were allowed to sit after 1922 until the last of them died, who was the Earl of Kilmorey in 1961. We relied very much on a view of the law officers of the Crown, very shortly after Irish independence, dated 1925. One of them was Sir Douglas Hogg, the father of the noble learned Lord Hailsham. The other was Sir Thomas Inskip. And here they said it may well be contended that if the effect of the Irish Free State Agreement Act is to take away the right of the Irish peers to be represented in the House of Lords, the existing representatives have no longer any right to be there. On the whole, we have come to the conclusion that this argument is not well founded. We regard the Act of Union as conferring on the Irish peerage the right to elect 28 of their body to sit for life as their representatives in the House of Lords. But we think that each representative peer had conferred on him, by the fact of his election, the right to sit for life in the House of Lords, and we do not regard that right, which is nowhere expressly dealt with, as necessarily taken away from the existing representatives by the legislation of 1922. And so that is the point, my lords. They did not sit by accident, which created the question of a barony by writ, although I may say here that with all the precedents of baronies by writ, which had been perhaps created by accident, there has always been an intention to create a peerage. My lords, the other point is too that I understand that no report of the Committee for Privileges, of which I have the honour to be a member, has ever been rejected by this House since the petition in the Ronda case, which was sent back by the Lord Chancellor of the day in the early 1920s for very, very different legal reasons. Otherwise, there is absolutely no precedent for what my noble friend Lord Monkswell, in his inimitable way, is attempting to do. Therefore, my lords, I hope that your lordships will reject the amendment.
My lords, I think that the House would probably expect me to offer a few observations in reply to the amendment as moved by the noble Lord Monkswell, and in doing so, may I thank him for notifying me before he tabled his amendment that he was proposing to raise this matter in some way. And I'd also similarly like to thank the noble Viscount Lord Mountgarret for having warned me beforehand too that he was intending to intervene in the debate. Well, lords, I'd like to thank all noble lords and noble and learned lords who've taken part in this debate. If they'll forgive me, as there has been a number of them, I won't refer to each of them by name, but I'm particularly grateful to the noble and learned lords, Lord Hailsham of St. Marylebone and Lord Jauncey of Tullichettle, for their contributions on legal matters involved in this particular case. Well, lords, it might be helpful in replying to the noble Lord Monkswell's moving of his amendment if I were to remind your lordships of what it is that your lordship's house is actually being asked to do. May I say, just before doing so, I would like to refer to the noble Earl Lord Longford's remarks, which were most entertaining, if I may say so. I must confess that I did strain myself during the course of his speech to see what was the precise relevance of what he was saying to both the motion and the amendment, and then, of course, it came to me all in a flash. It was a speech which had to be made. After all, this is Wimbledon fortnight. My lords, a petition for a writ of summons to this House is not a petition directed to your lordships. It is a petition to the Queen. Her Majesty, on the advice of the Home Secretary and the law officers, refers the petition to this House so that the House may advise Her Majesty as to what is the law with regard to that petition. By long established practice, such petitions are referred to the Committee for Privileges, who, under Standing Order 75, are required to sit with the assistance of not fewer than 3 Lords of Appeal. We, of course, had 4. When agreed to by the House, the decision is submitted to Her Majesty in the form of a judgment, preceded by the words, and I quote, "It is resolved and adjudged." Such a decision is not, therefore, the opinion of a majority of your lordships, but a judgment. It's a judicial proceeding analogous to, although not wholly comparable, with a judgment following a hearing before an appellate committee. My lords, in those circumstances, your lordships may feel that the House should only very rarely and for exceptionally compelling reasons seek to interfere with the report of a committee based on a judicial hearing at which Lords of Appeal were present and where those Lords of Appeal have given their judicial opinions. The noble Lord Monkswell's amendment is in the form used in 1922, as the noble Lord Strabolgi mentioned in the course of his remarks, which was the last occasion when this House asked the Committee for Privileges to reconsider a peerage case, the petition of Viscountess Ronda. On that occasion, as the noble Lord Strabolgi reminded us, it was in fact the Lord Chancellor who moved the amendment, and he explained that he was taking that unusual course because, in his view, the Attorney General had not put to the committee the relevant points of law, and that is the significant word, my lords, as your lordships will appreciate, which ought to have been considered. On that occasion, the House agreed to refer the matter back to the committee, and the committee, having considered those points of law, made a second report in exactly the opposite sense from their first report. It is, of course, a matter for your lordships, but the House may feel, particularly in the light of what the noble and learned Lord Jauncey has said as a member of the Committee for Privileges, The Ronda case does not provide a suitable precedent for the present case, in that there are no new legal arguments which would justify us in asking the committee to consider or to reconsider the matter all over again. And, my lords, I feel bound to add that if the committee were to consider the matter further, I myself have no doubt whatever that it would come to precisely the same conclusion. Lords, with these points in mind, and I hope that that background and the background indicated by others of your lordships in the course of this short debate will enable the noble Lord Monkswell to feel able to withdraw his amendment. If he felt unable to do so, then I would be bound to advise your lordships that it would be right not to support this amendment.
My lords, I thank all those noble lords who have contributed to this debate, and I think it has been very useful and informative. I would like to refer to a number of the submissions that have been made. My lords, in doing so, I would advise the House that I am minded to withdraw my amendment, but I think it would be for the courtesy of the House if I was to explain why, because if I did not explain, the House would not be correctly advised. My lords, the noble Lord Hailsham of Marylebone, in his inimitable style, discounted the ancient right of the creation of baronies by writ of summons. My lords, I'm not sure that he intended lèse-majesté, and I'm sure that would be a wrong interpretation. But, my lords, we have, as part of the proceedings of the committee, a report. I think the noble Lord Chair of Committees advised us that it was by an expert on peerage law, that, however, the Crown has the right to issue a writ of summons, either to a person who does not have a peerage at all, a peerage, or a person whose peerage does not entitle him to a writ of summons. My lords, that right, I think, still exists for the Crown. My lords, another point the noble Lord Hailsham said was that the Barony of Farnham ceased to exist, no longer exists. My lords, it does exist, my lords. It just doesn't entitle, the old Barony of Farnham doesn't entitle the holder to a seat in this House. He also said, and this is where I think he supported my arguments, that the Act of Union had gone by the board. My lords, the noble Lord Jauncey, and I'm indebted for his contribution, his noble and learned Lord's contribution to this debate is very welcome, advised the House that the noble Lord Farnham continued to sit by virtue of election for life. But, my lords, and this is where I really take issue with the committee, in the sense that they did not consider the basis on which that election for life was founded. My contention is that that was founded on the basis of the Union, the Act of Union of 1800, which a number of noble lords have effectively said, and the House has effectively said, in consideration of previous Privileges Committee, no longer existed after 1922. My lords, he made reference to the Scottish peers. My lords, they sat, or a number of them sat, between 1707 and 1963 by virtue of that Act of Union, which was not changed until 1963. He also suggested that it was not competent to issue a barony by writ, and I think I've referred to that, my lords. My lords, I'm indebted to the noble Lord Chairman of Committees for advising the House, reminding the House that this is consideration of a petition to Her Majesty, and we sit in a judicial capacity in this sense. But, my lords, I would point out to the House that we are all equal in sitting in that judicial capacity. My lords, I now come to the reason why I will withdraw my amendment. And my lords, that reason was given by the noble lord, Lord Glenamara. And he referred to a matter which I did not see because it was not included within the proceedings, and I can quite understand why. And that is that the writ of summons received by the noble Lord Farnham was in fact inscribed within it a condition that it was for life. Now, my lords, that is the legal basis on which we can agree this Committee of Privileges report. And, my lords, I hope that we are not in error in presuming that the wording of that writ of summons makes it very clear that it was only entitling the holder for a seat in this House for life. Because, as the noble Lord Mountgarret pointed out, this, I suspect, is the last opportunity we may have to put this matter to bed. My lords, I beg leave to withdraw my amendment.
Is it your Lordship's pleasure that this amendment be withdrawn? The amendment is by leave withdrawn. The question is that the motion be agreed to. As many as of that opinion will say content. If the contrary not content, the contents have it.
Message from the Commons that they have passed the Bells Bridge Order Confirmation Bill, to which they desire the agreement of your Lordships.